Claudia Newman for petitioners, South Sound, Bird Alliance, Gordon White, and Robert Metzger. And I want to thank you for the opportunity to present our case today. This case is about promises made to get a special use permit and now a rezone sought to break those promises. In 2018, Black Lake Quarry's predecessor stood before a hearing examiner seeking approval of a special use permit and made a promise. They would mine in 7 phases, finish by 2035, and they would restore the property, and I'm quoting, as an evolving reclaimed ecosystem with new beneficial habitat features, allowing it to, again quoting, revert to the underlying R120 zoning. They also said, the representative said, the water right would be available for future beneficial use. And the reclamation plan proposed a forest and a lake, 300 trees, tall shrubs per acre, including Douglas firs, cedars, hemlock, and maples. And that was the plan. That's how they got their special use permit. That's how they got their foot in the door for mining. Now, 7 years later, with the mine nearly exhausted, getting closer to 2035 here, the mining company sought and received a rezone of the property from R120 to rural resource industrial. And the worst than that is they point to their own mining activities to justify the rezone. This is despite that they got their foot in the door to mine with a promise to restore the area. And with the rezone to rural industrial, obviously the reclamation will not happen. The property will instead be permanently industrial with uses that are even more intensive than the grabbing mining on every level. And this is important for the legal issues because Black Lake Quarry attempts to set the baseline throughout its brief and its arguments as existing mining operations against the industrial uses that would be allowed under the industrial zoning. But that's not the baseline. The baseline here is reclamation plan that was supposed to occur and keeping this at R120 and reverting it back to R120 when the gravel mine is exhausted. Now, with our appeal, we're asking the board for 2 things. First, a finding that the ordinance and the resolution, ordinance is 16575 and resolution is 16574. Those are that we were talking earlier. The record number 352 is the ordinance. Record number 353 is the resolution that's being challenged. We're asking that the board rule that they're clearly erroneous with respect to the rezone to RRI. And also we're asking the board issue a determination of invalidity under RCW 36.78.302. Continued validity would substantially interfere with GMA goals, and Black Lake Quarry would use any remand period without invalidity to vest development rights for industrial uses of this property and render correction on remand meaningless. Now, time allowing, this morning I'm going to try to cover 4 areas. The first is I want to point out some demonstrably false factual premises on which the commissioners voted. It shows when you look at the conversations that happened in the PowerPoints, it shows us that the decision to rezone this property was made on false information and relied on false information. And second, I want to talk about why this site fails the comp plan's locational criteria for the industrial designation. Third, I'm going to touch on quickly, if I have time, why the rezone fails to meet the comp plan criteria for a rezone in a rural area. And then finally, why it's inconsistent with environmental policies. Those are, if I have time. I do have one housekeeping point before I go further. Petitioners have withdrawn issue 6 and issue 13. We are not asking the board to rule on either of those. I flag that now so the board and opposing parties can set those aside. And I also have a very quick comment on the clearly erroneous standard. The clearly erroneous standard, I think it's, when you look at the case law and you read what the courts say about it, it gets misconstrued by counties sometimes and developers. It is a very broad standard of review. That is, I am quoting from Polygon Court v. City of Seattle, 90 Win Second 59. It calls for a higher degree of judicial scrutiny of agency decisions than other standards. It is extremely broad. Another case that said that is Sisley v. San Juan County, 89 Win Second 78. And then a Growth Management Hearings Board case, which was Snohomish Indian Tribal Community versus the Western Washington Growth Management Hearings Board, 161 Win Second 415, said it requires
when you're when you're citing case numbers and stuff, can you slow down a little bit? I have to type every single number and it kind of blends together sometimes.
Okay. I will do that, of course. So the last one I just cited was Swinomish Indian Tribal Community versus Western Washington Growth Management Hearings Board, 161 Win Second 415. And so generally that in that case says that the board gives the action a critical review and it is more intense standard of review than arbitrary and capricious standard. So basically, if the county made a mistake, if you see that the county made a mistake, that meets the standard after you've looked at the whole record. And so it's a very increased judicial scrutiny of a decision. Now, my first topic, as I mentioned, is that there are 4 demonstrable.
Hold on just a minute, Mrs. Newman. Can you go back and just give the court reporter the site for Polygon that you
of course. I'm
said,
so
and then
sorry.
also Sisley.
Yes, my apologies. Okay. Polygon Corp v. City of Seattle was 90 Win Second 59. And then Sisley v. San Juan County was 89 Win Second 78. Is that resolve that?
Ms. Knudsen, was that okay?
Yes.
I'm
Okay,
so
great.
sorry. I will try to slow down as I go forward. So the 4 demonstrably false factual premises, it's relevant to the subject of deference. So the Growth Management Hearings Board can't defer to a decision that was made based on false information. So we're not asking this board to reweigh the evidence. The commissioners didn't even weigh the evidence adequately. They didn't consider the correct facts. There's no legitimate judgment to defer to. For example, what first false premise is that the commissioners believe that approximately 24 acres of Oregon spotted frog critical habitat had been carved out of the ordinance, out of the rezone. There's a PowerPoint saying this. They said this on the record. That is not what the ordinance did, and it's very clear on its face. Record 352 at page 10353 is finding 2 of the ordinance, and it says it rezones 270 acres. That's the entire property, no carve out. It lists all 4 parcel numbers. There's no exclusion. Section 6 of the same ordinance at page 10354, no exclusion. Look at the map, Appendix E, 10527, no exclusion. And then the resolution, which is record number 353, says the same thing. And the map, again, shows all 4 parcels. We've at least 5 locations in the enacted text, all 5 consistent, all 5 rezoning the entirety of 4 parcels. Now, Black Lake Quarry calls this a Scrivener's error. This is not a Scrivener's error. The Scrivener's error doctrine exists for minor, obvious technical errors, like a misplaced word or a typographical error.
Can I interrupt for a moment?
Of course.
Is the Scribner's error point first raised in this case? I mean, is there anything in the record that indicates the county itself recognized this as a Scribner's error?
No, no. There's nothing in the record. This was brought up as a defense in Black Lake Quarry's brief.
Thank you.
So the second false premise is that the commissioners believed and said during their deliberations that this rezone was going to prevent wet mining. Several commissioners expressed their belief that the rezone would prevent this below water table mining, and so it would stop Black Lake Quarry from digging into the aquifer. Black Lake Quarry's own response brief admits at page 31, this is false. Wet mining is allowed. This is phase 7. It's allowed with or without the rezone. And there's no reason to assume, or there's nothing in the record that, tells us that wet mining will not occur under, I mean, it's allowed. I guess what's more important is even if they made a promise, it's legally allowed. So someone else could buy the property and conduct wet mining. There's nothing stopping wet mining from moving forward. So
I'm sorry, Ms. Newman, you said that the commissioners assumed that the rezone wouldn't prevent wet mining. What's the basis for that, for your allegation on that?
There's board deliberations. Commissioner Mejia, I don't know, thought it would be more damaging to the aquifer if they kept the zone, if they didn't do the rezone. Based on that, they thought, there was this assumption that they had to rezone to RRI to prevent this damage to the aquifer.
Okay, do you have citations to that for us so that we can look at that?
I don't have them memorized, but I can refer you to our opening brief, pre-hearing brief, page. So there's page 25. It says the board also relied on speculative fears regarding future below water table mining, and we have several citations and paragraphs following that.
Okay, thank you. Appreciate it.
Then another false premise is that they said during the deliberations, without the rezone, the site, there was a commissioner that said, without the rezone, reclamation would leave nothing but an unusable pit, and then I quote, just a giant hole in the ground. So they thought that the rezone was going to improve the environment because there wouldn't be a giant hole in the ground left behind. But the record obviously contradicts that. The current special use permit under the current zoning requires reclamation, and the reclamation plan is to restore it as I described in my intro, with a full forest and a lake and habitat features, and it would revert to rural residential zoning. So they voted to prevent an outcome that the law already prevents.
Can I ask you for a little more detail on that point, Ms. Newman? So I am interested in the difference between the reclamation/restoration that are required as a condition of their SUP when mining is finished versus whatever reclamation would be required as a matter of statute by DNR. And the reason I'm interested in that, it strikes me like once, now that the rezone is in place, if the applicant decided to switch to a different use than mining, they could just walk away from the SUP and not fulfill any of its restoration conditions. And the penalty for violating an SUP is typically that your SUP is revoked. But if mining is complete anyway, they might not care about it. Now, there's no walking away from a statute. So if DNR is going to hold their, feet to the fire on restoration and reclamation, then maybe that doesn't matter. So can you explain to me a little bit the difference between what they'd have to do if they were
Yeah.
stuck with the permit versus what they'd have to do if they were
Sure.
only under statute?
And I do want to emphasize, I agree that they can walk away from the special use permit, and that's a major problem. The reclamation for DNR from their jurisdiction and their perspective is tied to the underlying zoning. And so if you have an industrial zone, you're reclaiming for purposes of industrial use. So that's a lesser protective standard than the R120 zone.
Do you have a statutory site for the argument that the amount of reclamation or the quality of reclamation is based on the underlying zoning from DNR's
I
perspective?
had it, I knew
If
it,
it's in the brief,
and
you can
I
just
don't have it now.
okay. Is it in the brief somewhere though?
I will check. I can't remember. I remember vividly looking at it and reading it, but I can't remember if I put it in the brief.
Okay,
So, but I can get it for you.
it's not a statute that we get our hands on much here at the board, so I'm a
Right.
little bit unfamiliar with it.
Or even
It's-
if you're at your time, during to reply, if you could
Yeah.
let.
Right. I will, yeah, I might be able to get that for, I will get that for you.
Okay, thanks.
I can't recall what it is. Okay. So the, I can tell you, I mean, the main point here is that they thought they were preventing a giant hole from happening. And so the main point I'm trying to make is that the commissioners were under incorrect assumptions when they approved this rezone, thinking it was going to make the situation better. So the fourth false premise is that they also thought that there was a scarcity of rural resource industrial land in rural areas. So they had to approve this to introduce more rural lands. My voice might get scratchy because I have allergies. So there was a study, industrial land study, and that study explained that conditions in the code limited the area that could be designated as RRI zoned land. And those specific conditions, those were in TCC 20.29.020. They required that RRI be located within 1/2 of a mile of an I-5 interchange. They required vehicular access from a county arterial or collector road or state highway. So in other words, in the code, before anything could be designated as RRI, those conditions had to be met. That's pretty limiting. A piece of land that's a 1/2 mile from I-5. There's not a lot of land like that. So according to the study, when you apply those conditions, there were only 97 acres of developable land available under those constraints. But the trick here, the problem, is that the same day the Board of Commissioners approved the rezone, they also amended TCC 20.29.020, and they removed the constraints. Well, they had to do it because this property doesn't meet those constraints. And so they moved the constraints entirely from the code. There's no more limit. It doesn't have to be a 1/2 mile from I-5 interchange. Doesn't have to have vehicular access. But when you delete that, the criteria that defined what counted as viable rural resource land in the study, you don't have a genuine scarcity finding anymore. In other words, if a study was done again today under this new code, there would be a lot more land available for RRI. So that was a major mistake on their part. So there's 4 false premises, and that's on the right. That's what the the commissioners were thinking when they voted in favor of this. And deference is just not appropriate when mistakes like that are made. So my second topic is related to the locational criteria in the comprehensive plan. And it's important to, well, I guess just to start, even if there were no deference problem, even if the commissioners voted on entirely accurate facts, this issue is relevant because the property clearly fails the comp plan's locational criteria for a rural resource rural resource industrial designation. So the comp plan is clear. And I might have to share the screen here. I don't know if I'm allowed, if I'm given permission. But it states, so first of all, we have to look at this in a holistic way with the comp plan, because the comp plan defines locational criteria for rural 120, which is what this is right now. And the comp plan states locational criteria for rural industrial. And it states that the R120 designation is appropriate for lands that are within the Black River corridor, uses that term, along the Nisqually Bluff, or are severely constrained by environmentally sensitive or hazardous areas. So that's when you should be doing R120. In our brief, we explain, in our reply brief, we explain what the Black River corridor is, because we referred to it in our opening brief, but we explain what we're describing in our reply brief. And I think it's best to see this as a visual. This is something that you really need to see to understand. So if I could share.
It looks like you would have the ability to share.
Excellent. Okay, so can you see this map that I have up on the screen? I'm hoping I'm not
Yes.
sharing my outline and I'm sharing the map. Okay, I have been known to do that in the past. So okay, like Snohomish County, when presiding member Ehrlichman was describing Snohomish County's massive ordinance that created new rural zoning, Thurston County did the same thing. I think it was around 2007. And because of a Growth Management Hearings Board case, FutureWise had pushed Thurston County to adopt more different types of rural zones, because they had only one and it wasn't adequate. So they had to adopt a new ordinance, and that ordinance was 13884. We attached that as attachment A to our brief, our reply brief. And when they did that, this is a map showing you the zoning that was adopted by that ordinance so for the first time, they created this R120 zoning. It hadn't existed before this ordinance. This was back in 2007. And in that ordinance, you can see the whereas statements say, okay, whereas we're creating this R120 to protect the Black River corridor, all in caps. That's what this is. See this R120, you can see it's all the way down the Black River corridor. They've zoned it to protect the Black River. This corridor is mapped and defined by Ordinance 13884. And the ordinance itself, the code, when you look at the R120 zoning in the code, it's Thurston County Code 20.09B.010. The purpose of R120 zoning is to protect the Black River corridor. That's what the purpose is of that zoning. So, as you can see, this is the property right here, Black Lake Quarry rezone. This has been rezoned to industrial. It is in the Black River corridor as that was mapped and defined by Ordinance 13884. That's what we were referring to by the Black River corridor. So I'm going to end my share. Actually, hold on. Sorry, I messed up. Stop share. I do have another document I'm going to share, but I want to make sure I leave room for that.
And if you would, Ms. Newman, before you get into too much detail on what the comp plan locational guidelines require, can you establish for us that the comp plan locational guidelines are supposed to guide the zoning decision? Is there something in the code that says, hey, when you're doing a site-specific rezone, whether that's being done, legislatively as part of your comp plan update or quasi-judicially, as part of the annual docket, whenever you're doing it, make sure you follow those locational guidelines in the comp plan, because without a requirement to follow the locational guidelines, they don't control.
Well, it's in the comp plan, and there is on page 3-9, there is an entire section called land use designations in the comp plan. And it says this section of the land use chapter describes each of the land use designations shown on the future land use map. And then it says the following descriptions of the land use designations and the associated policies in this chapter, so that's what they're referring to, the locational criteria, are important to the comprehensive plan. Policies in this chapter provide guidance in determining the appropriate land use designation for rural lands. Lands within UGAs, blah, 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 blah. And then it says designating land use throughout the county is complex. It requires blah, blah, blah. And then it gives you guidelines. These are guidelines specific to, it says the table below lists the general guidelines for designation decisions, which is what this is. And it breaks them into locational criteria guidelines and other decision-making guidelines. And then you have
And is there equivalent language in the code that says, when doing a rezone, make sure you refer back to the comp plan guidelines and follow those?
well, I don't remember. I will have to look at that. I'm not going to answer because there may be. But also, legally that is not necessary because the issue here is that there has been a designation amendment of the future land use map. And that has to be consistent and implement the comprehensive plan.
Yeah, I certainly understand the
Okay.
internal consistency requirements. I was just wondering if there's something further than
Okay.
that, that we can also.
I will definitely look. There's the thing that got a little mixed up is you may have noticed in our opening brief, we focused on the wrong provision, which was a site-specific rezone provision.
Right.
There are two provisions in the code. One provision speaks to legislative rezones.
Yeah.
And that's what I would look at to see if it's there. And I don't have that in front of me right now.
Okay.
But
All right.
I'm hesitant to say it one way or the other, answer it
gotcha.
without having that language in front of me.
Yeah, I got you. And I'm not trying to trip you up or anything like that.
No,
I
just want to make sure I'm answering.
Yeah. I got you. Okay, very good.
Okay, so all right. Now, then you look in contrast at the designation of land as rural resource industrial, and they're telling us that you should not designate land as industrial in a rural area if it should have minimal environmental constraints, and it should generally be free of critical areas. And it's particularly important that land designated as RRI can support industrial uses without significant adverse effects on surface or groundwater. So as we outlined in our brief, this site has a lot. I don't know if I've seen this many before of environmental constraints. I'm going to actually share a map again, share a photo again, but see. So this is record number 627. There are a lot of images in 627 that are useful to look at. I won't be showing all of them to you today for time, but they kind of run right. You can peruse through them. This one has a nice outline of the Black River National Wildlife Refuge area. It's this lime green. And I want to note that in our opening brief, we pointed out, it was to the north and to the west of the site. And obviously, I guess it's obvious, this red area right here is the property that's been rezoned to industrial. It's literally like right adjacent to a national wildlife refuge. And then there's more, this little green piece right here is also national wildlife, or it's federally owned land the way it says here. I'm assuming it's part of the National Wildlife Refuge because it's also in this mint color. Now, I just want to pause for a second to understand the significance of this being a national wildlife refuge. This isn't a national park. This isn't a national forest. This is a whole different level of protection by the federal government. This is an area that prioritizes protection of fish and wildlife. That is the purpose of this land being protected. The entire idea here is that it remains free, roughly free of human interference and influences. We are protecting fish and wildlife in this. This isn't even a national park. This is a whole extra level. And they're proposing, or they have rezoned this land immediately adjacent to it for industrial uses. And I do want to point out, while I've got this open, because it's a little bit of a tangent, but I do want to point out this map is showing mineral resource areas, and it's worth noting that a portion of the property at issue is does not even have a mineral resource overlay. This was rezoned to industrial down here. Also, while I've got this open, just because it's easy, this is 93rd Avenue Southwest. And I just want to point out that there was either an implication or a statement or some sort of, hint that this site was connected to 93rd Avenue Southwest. It is not connected. There is no connection. There is a large gap here. This site does not have a connection to that road. It's relevant for other reasons, but I just wanted to point it out while I had it up on the screen.
So Ms. Newman, you have about, you're actually technically out of time, but I'm going to
Oh
give
my
you 10 more
goodness.
minutes to finish up.
Oh my goodness. Okay. That is okay. I guess thank you so much. What I want to do is very quickly point out, because this was not in our brief, the consistency issue overall, the legal cases associated with that, and kind of what the board needs to look at for that legal issue of consistency with the comp plan policies. And this is mostly relevant. Well, it's relevant for the environmental policies and other policies in the plan. I mean, it's going on. So Black Lake Quarry cited 3 Court of Appeals cases to support their case. And none of those cases apply here. I don't have time to go into it, but I just want to emphasize that those cases, I urge the board to review those cases, because it is very clear that they are not applicable in this case. They're also extremely fact specific. This is a very fact specific analysis that requires a look at the policy and a look at the facts to make a determination. But I do encourage the board to be led by 4 critical growth management hearings board cases that I think this situation is very similar to. And so I ask you to look at Martin v. Whatcom County, case number 11-2-002, and that was decided on July 11th, 2011. And then Ann Agard versus City of Bothell, very similar to this case, case number 15-3-001, July 21st, 2015. Kittitas County case number 11-1-001, July 12th, 2011. Nilsson versus Lewis County, case number 11-2-003, and then finally Paranzi versus City of Olympia, case number 11-2-011. When reviewing these, it's critical to recognize that the board knows that, has made rulings of inconsistency in situations that are very similar to this, and those will give you guidance and some feel for why it's appropriate to make that ruling here. Another thing I just want to point out with this shortened time is that the provision in the code that identifies the uses that are allowed under rural resource zoning has not been, you shouldn't go online to look at that provision. I am, because I'm scrambling, I don't know if I have the site right in front of me, but oh, okay, here it is. So TC 20.29.020 is the provision that tells us what uses are allowed in the rural industrial zone. And I just want to point out that if you go online and look at it, it hasn't been changed yet. So to know what uses are allowed under the new ordinance, because they amended that provision too, and it's important to know what's allowed because they changed what's allowed in that zone. You have to look at record number 352 at Bates number 10409. And it's very important to see what's allowed uses because that goes directly to the inconsistency of this development regulation, essentially, this rezone with all of these policies. So in closing, we ask that the board enter a determination of invalidity. Continued validity of this rezone would substantially interfere with GMA goals, as we explained in detail in our brief. During any remand without invalidity, there is no question that Black Lake Quarry would file a development permit application, and the permit would vest on submission of a complete application under the industrial zoning, and that would basically render any correction on remand largely academic. So we request invalidity and an order of non-compliance. Thank you very much for your time.
Thank you. I'm turning to my board members. Are there any questions for Ms. Newman right now, other than those we've already given her?
I don't have any questions.
No, although I would appreciate that citation to the DNR rules for reclamation, Ms. Newman's argument that whatever the underlying zoning is, that's your reclamation target for
Okay,
statutory
I actually think I have that now.
Oh, all right.
Like it. WAC 332-18-010 sub 4. And then there's a definition section, which actually I don't have, which is separate, I think.
Is it in your brief?
Completed reclamation. It might be, that might be the right site. I'd have to double check. Someone sent this to me and I will check my brief to see if it's in there.
I don't see that site in your
No, I don't
brief.
think it's in there actually.
Yeah. Well, anyways, we can come back to it. You'll have a little bit while Miss Burgess is doing her argument.
Okay.
Yeah,
Well, I might have to listen.
Yeah, no,
I might do it during a break.
No, yeah, this is a heck of a way to do
okay.
statutory research.
Yeah, it's hard to listen and research
All
at
right.
the same time. Okay.
All right. So before we turn to Ms. Burgess, anybody need a break terribly at this point? Just keep going. All right. Ms. Burgess, you're up.
I'm struggling with good morning or afternoon, but it's 11:56. So I will go with morning for the first 4 minutes, if that works.
That's fine.
Morning. I appreciate the opportunity to be here today on behalf of the intervener, Black Lake Quarry, LLC. I had followed the board's kind of original agenda sequence in preparing this argument, in which I'd allocated time as between myself and Mr. Burns. And so I have planned roughly 20 to 25 minutes worth of presentation subject to the board's questions. And then Mr. Burns may have a couple points, especially given the questions regarding the county's ordinances and resolutions and their correctness, which he may I think is probably appropriate for him to cover. So that hopefully gives you a little bit of a roadmap here today.
Yeah, we have allocated 40 minutes, so use it however you would like.
Terrific. Thank you, Ms. Ehrlichman. I appreciate it. I think what I'd like to do, actually, before I get into my 4 points, and mainly so that I don't lose track of them, is address a couple of items that came up from the board's questions to Ms. Newman. Specifically, in addition to the WAC that Ms. Newman just provided in response to Mr. Seidel's as pertains to DNR reclamation, there's a statutory site, RCW 7844091. Hopefully that was slow enough for Ms. Knudsen. Which discusses the required narrative in the reclamation plan to identify a post-mining use consistent with local land use designations. The WAC that Ms. Newman cited goes into the specifics of the reclamation plan requirements, but there is an overarching statute. And what's relevant is that a reclamation plan does not vest a subsequent land use. So an initial reclamation plan for a mine has to be provided in order for the mine operator to obtain its permits and obtain its SM6 from the Department of Natural Resources. But that does not vest any specific subsequent land use. And the reclamation plan could be changed at any time. And when it's changed, it must then conform with the reclamation requirements of the then existing zoning. So I think there's a lot of reclamation and mining is complicated. I'll just kind of leave that there. And there's a lot of cross-pollination of terminology. There was a lot of information that was presented to the Board of County Commissioners in reaching this decision by my client, the mine operator, who explained some of this information, but it is technical and complicated. And I think it's important to not conflate what the DNR might require with what the county's obligations and duties are in considering a rezone of this in this manner. The second item I wanted to make sure I covered is this question of legislative versus site-specific rezone. We appreciate that petitioners have withdrawn their issue 13. We fully agree that this was a legislative rezone. We argued the criteria presented in the issue because we had that move to dismiss it. And so we'll leave that there. But what's important about the legislative rezone is there are specific code requirements in Thurston County Code 2059-050. There is no specific reference or inference to the locational criteria that are in the comp plan. But to Ms. Newman's point, those were addressed and discussed by the board in reaching its decision. So whether they were incorporated by specific reference in the code or not, it's clear that the board considered them in reaching its decision.
So you agree then that the locational guidelines do have legal significance?
I think they have legal significance in that the designation has to be consistent with those criteria. Okay. So I would agree with that point.
All right.
I prudent or not, I would agree with that point. But as to the characterization of as a legislative rezone, what's also important is in reply, petitioners use that characterization of the legislative rezone to assert that this amendment to the zoning map and the future land use map that was made is equivalent to a development regulation under the Growth Management Act for purposes of your consistency analysis. And with that, I must respectfully disagree. Because when you look at the definition of a development regulation in the Growth Management Act, which is in 3670A 030 sub 14, it's controls placed on development or land use activities by a county or city, including but not limited to zoning ordinances, and then list of stuff, other things not relevant to the board's determination here. A zoning ordinance is the land use control. That's a development regulation, but that's not the same as the zoning map, which is what's at issue here. And we believe it's inappropriate to bootstrap additional argument or a new issue about the rezone needing to implement and not just be consistent with the comprehensive plan on that basis, because that was not initially part of the statement of issues presented.
I think you might have split the hair so finely that I can't see it anymore. What's the difference between a zoning ordinance, which is a development regulation, versus the adoption of a zoning map, which you say is not a development regulation?
Right. So thanks. That's a great question. So if you look at a zoning ordinance, it has very specific criteria, permitted uses, specific uses that are allowed, specific uses that are prohibited.
Those are the controls placed on the use of the land.
That's right. And that is and then it has maybe bulk and density requirements.
Sure.
Other specific controls. So the implementing ordinance for the development regulation is the zoning ordinance. The map is what says what zoning ordinance applies within your map designation.
But when you change the map, aren't you changing which controls apply to the use of your land?
Yes, but for purposes of implementation and consistency under the Growth Management Act, especially if you look at several of the provisions that petitioners cite in their briefing, they're talking about implementation of things that you would find in development regulations such as critical area ordinances or stormwater regulations. And so my understanding of their argument is that those provisions are then controlling in a different way because this should be interpreted as a development regulation. And I don't believe that was articulated in their issues, and I don't believe that's legally correct.
I mean, I think if the change to a map is not a change to a development regulation, then the board wouldn't have jurisdiction at all. This would be a LUPA case. So it has to be a development regulation. Otherwise we can't be here. Right?
I don't think so, because you would have a comprehensive plan map amendment, and you clearly have jurisdiction over changes to comprehensive plans.
Right, but not the zoning map change, according to you.
No, I think you do, because it was classified as a legislative rezone, and the legislative rezone officially changed the zoning map.
So,
Right.
Ms. Burgess, I'm going to chime in here because, I just had to. So the word controls, what do you think that means exactly? And isn't there a definition in 3670, the Planning Enabling Act, that gives us a very specific idea of what that was supposed to be?
I do not have that open right in front of me, but I don't disagree with you. What I
Okay.
was trying to make, and I'm not sure I'm getting it across, but the point I was trying to make was, for purposes of the consistency argument, the way that the implementation provisions work is different for a map versus the actual ordinance. And
Okay, but
changes
official control does include the adoption of a detailed map under 3670, which is
yes.
kind of the parent statute to 3670A. So I would look to that for a definition. I didn't look in the GMA, but I knew that the Planning Enabling Act uses the terminology of official controls. So it looks like it does include detailed maps, at least under 3670. So if you have a reason why 3670 doesn't apply to the GMA, let us know, or whether you dispute that. But it does seem to apply.
Noted. Thank you.
Okay.
I appreciate it.
For now, let's at least assume the board has jurisdiction over the map change, for heaven's sakes.
I am not disputing the board's jurisdiction over the map change. I am trying to make a more technical argument about new issues raised in reply by the petitioners regarding the extent the change to a legislative rezone drawing in as a development regulation in a new way
I
from
get
the
that.
original
And,
argument.
and certainly
That was the intent
no,
behind
I got you. No,
raising
yeah,
the point.
I regret bringing this up, but
That's
no,
okay.
certainly it's not the case that if it is a development regulation at all, certainly not every development regulation must implement everything in the comp. It doesn't all just funnel into one little thing. That even for text amendments, that doesn't happen.
Right. Understood.
All right.
Thank you. So those are the two things I wanted to make sure I covered to begin with. I think the elephant in the room otherwise is, what is the scope of the county's adopted rezone here? So, whether or not it's 270 acres or 247 acres, as was presented to the Board of County Commissioners as the applicant requested subsequent to the Planning Commission's review of this matter, is highly relevant to many of the petitioner's arguments, including the extent to which there's critical areas on site, the nature of those critical areas, the potential impacts of the rezone to those critical areas. And the evidence of the intent to exclude the 24 acres from the rezone is clear and plainly in the record. The relevant finding from the ordinance, which Ms. Newman cited, it's record 352. It's on page 7 under F for the Black Lake Quarry zoning map amendment, describes the action amending to change the land use designation of approximately 270 acres, and then it lists 4 parcels and the address, from rural 1 dwelling per 20 R1 to 20 to rural resource industrial. The parcel numbers are correct in the finding because entire parcels were not removed with the revision. The only thing that's incorrect is the total acreage, which should have stated approximately 247 rather than 270, with a corresponding change to the map. For further clarity, the finding could also have indicated that portions of 3 of the 4 parcels were excluded. Importantly, findings 7 and 8 within the same ordinance identify the dates of the board briefings on October 15th and 21st, 2025, and the public hearing on November 12th, 2025 within the ordinance. And if you look at the maps that were presented in both of those, and those are cited in our materials, so it's record 642, Bates number 24846, which we also snipped into our briefing at page 3. And then again, from the same map was shown on November 12th, 2025, that time record 648, Bates numbers 26268. It clearly states there was a revised rezone proposal. It's in all caps and goes on to describe it in some detail as excluding critical areas associated with the Black River. The petitioner's materials included submitted transcript excerpts from the November 12th, 2025 public hearing that include clear statements from Ms. Ashley Arai, who's the planning director, and Mr. David Toyer, who was the applicant's representative, explaining that the proposal had specifically been revised to exclude those 24 acres of critical areas. What the intervener applicant cannot explain is why county staff did not update the description of the proposal or the map. It was changed subsequent to the Planning Commission's consideration, but prior to the board action, and it should have been fixed before the board voted on it. But it does not change the substance of what the board discussed or believed it was voting on from the record, which was the revised proposal.
Ms. Burgess, is there any chance that we will hear from the county on that point? Because you're the only one that's briefed this issue. And I think I'd feel a little bit more comfortable if we had Mr. Burns say, yep, sure enough, this was a sustained administrative error. I won't say the magic word Scrivener's error right now, but this was a sustained administrative error. We really weren't trying to smuggle those 24 acres in. They were supposed to be left out. I think I'd feel more comfortable hearing that from the county than from you, just because of, not because of you as an attorney, but just because of the positions of the parties.
I certainly understand. That's my understanding from speaking to Mr. Burns, and believe that Mr. Burns will address that subsequent to me.
All right.
I would also note in the ordinance on page 8 in section 9, the county does include a specific provision allowing for corrections specific to Scrivener's errors. And so within the ordinance itself, it does create a mechanism for there to be a correction.
I mean,
and
but
again,
this is a pretty big Scrivener's error. I mean, the map, the text, over and over. I mean, geez.
Again, not something the applicant can really explain, other than it being, one. I think earlier, Mr. Seidels, you were scrolling through, and it's 1,582 pages long, and things got missed. And I would expect and hope that the county will answer the board's appropriate questions on that. But it is our, and if you look, the other thing I could tell you is, if you look in county geodata mapping, it reflects the 247 acre boundary today. So the county can verify all of that, but it's our position that what needs to be done here is a correction to the ordinance and resolution, and that the case that was cited by the petitioner's community lodging is distinguishable on the Scrivener's error point, because that Scrivener's error, or alleged Scrivener's error, had challenges with public comment. And here, the revised proposal is what was presented to the public and discussed and commented on by the public at the November 12th, 2025 public hearing. So we don't have that omission.
So just to be clear, you believe the county needs to go back and do something to fix this?
I think the county needs to make an administrative correction using section 9 of its ordinance to correct the description in finding 2 of 270 to be 247, and to conform the corresponding map in exhibit, I think it's Appendix E, to the ordinance, to the revised map that was shown to the board in the 2 prior maps that were cited, to reflect the exclusion of those 24 acres. So as you could tell from the briefing, we've premised, I'm mindful of my timer, we've premised our argument on that acreage properly being excluded for purposes of the critical areas based challenges, for there having been flood zones or shoreline, large on-site wetlands. If one applies the 24 acre exclusion that we believe the applicant intended to be considered, and that the board in fact considered as part of the discussion, then the principal critical area remaining is a critical aquifer recharge area. And as noted in our briefing, most of the critical aquifer recharges, most of Thurston County happens to be in a CARA of one form or another. And if that argument were fully vetted out, it would be difficult to have industrial lands basically in any location.
Ms. Burgess, is this a good time for you to talk about the CARA? not just in the 24 acres, but let's assume that those are properly excluded here, and we're just talking about the remainder. Um, Looking at the maps, I don't know that I have a percentage for you. So this is me kind of shooting from the hip and squinting at different colors at the maps. It looks to me like, a little more than half of it is a category one Cara, and then like maybe another like 35 to 40% of it is a category two Cara, and then there's a little part of it that's category three Cara, and then none of it is entirely free from Caras.
That is correct.
Okay, yeah, and I'm not holding anyone to the numbers. I mean, that's that I just made those up. Um, the category one Cara is the most protective level, obviously, and especially when it comes to industrial uses. There are a multitude of industrial uses that can't be done on a category one Cara, at least as I understand it. And the reason this becomes relevant is when I go to the comp plan's locational guidelines. Um, it says land should generally be level, okay, fine, and free of critical areas. Well, we've got, the Cara problem, but the one that really jumped out at me was this: land should be capable of supporting industrial development with minimal environmental constraints. And here, where more than half of the property would exclude more than half of all possible industrial uses, that strikes me as more than a minimal environmental constraint for the industrial use of this land. And I'll just level with you. I thought that this was petitioner's strongest argument. So that's why I'm putting it to you here. How can you say that it's minimal environmental constraints when so much of the land base there is so thoroughly constrained as to certain industrial uses?
Certainly. So I think there's two things to consider in response to that concern. First of all, the locational criteria refer broadly to all forms of critical areas. Critical areas, as you know, include a wide range of features: wetlands, geologically hazard areas, all kinds of other things upon which one cannot do anything.
Well, yeah,
right?
of
And
course.
cannot
And as you say, there's nowhere in Thurston County that is free of critical areas.
Right.
So I'm not going to, read this so strictly that it's like, well, I guess that's it for, industrial uses in Thurston County. They're all excluded. No, I think the more operative language here is that the land should be capable of supporting industrial development with minimal environmental constraints. And the reason I focus on that is, if you found a similarly sized parcel that was all Cara category three, for example, then you could do those industrial uses. So that would be the place that these locational guidelines are nudging you to put this type of zoning. It's not, I don't want there to be a red herring here where it's like, oh, we're trying to get rid of all industrial zoning everywhere. No, I mean, we're
Don't mind me and my timer here. Okay.
Oh, well,
there you go.
my questions don't count against your time, so this is actually helping you. This is bonus time.
No, it was going off. I didn't know if you could hear it in the background.
Oh, okay, sorry, no. So I rather than focus on this thing like, is it free of critical areas or is it not? I mean, the maps speak for themselves. I think what's more interesting is, can you actually do industrial development here free of environmental constraints, or do we have a level of environmental constraint here that is more than minimal?
Certainly. So I think you have to look at the locational criteria which were created in the comp plan before the Board of County Commissioners took a concurrent action with adoption of this ordinance to modify and constrain the types of uses that are permitted in the RRI zoning. And so it was at the time that those locational criteria were developed, there was a far broader range of uses that were permitted in the rural residential industrial zone, or rural resource industrial zoning. Those uses have now been significantly constrained to those which directly support other resource uses: agriculture, forestry, mineral extraction. And the Board of County Commissioners intentionally did that. So I think it's important to consider when applying those criteria, if you take the locational designation, you consider the actual range of permitted. We want to be free to use this property in a way that's consistent with industrial uses, and then look at what the CARA prohibits in those areas, right? it prohibits uses related to asphalt, cement, and concrete plants, which are currently prohibited separately by the covenant, chemical manufacturing and processing, and commercial or industrial uses that use or generate more than 220 pounds of hazardous waste or materials per month. And it goes on to, some other lists. It's important, I think, to place the CARA restriction in context because those designation criteria anticipated a much broader range of uses than the current RRI zone with the amendments would otherwise prohibit. So then the question is, are you unduly restricting the industrial activities that would be permitted to support those resource uses? And if you compare the code with what's allowed under the CARA, we don't believe that to be the case.
Does the CARA cost you any potential uses that you could do under RRI? Because I understand like asphalt you can't do because of the CARA rules, but you say, well, RRI has been amended so you couldn't do asphalt anyways because it doesn't, directly support a mineral use. Do you lose any uses, or is it your position that the CARA restrictions don't cost you anything that RRI doesn't already cost you?
I would be misrepresenting myself to the board if I said I had gone a use by use table analysis to answer that question. I have not, but it's my understanding that the general range of newly permitted uses is not going to be significantly restricted by the presence of the CARAs on site.
Understood. And certainly it's not your burden to go use by, it's petitioner's burden, frankly, to go kind of use by use and say, well, look at all these uses that they can't do. That's more than minimal environmental constraints. So, okay. All right. That's a fair answer.
Right. And the other thing too, it's important to recognize that those uses are then subject to land use review. They're subject to SEPA. They're subject to the CARA restrictions. And so there's kind of an inference in the briefing that somehow there's going to be unrestricted, unbounded industrial use that occurs on the property with the rezone, and respectfully submit that that's also not going to be the case, that those CARA, the county was allowed to consider that it had those CARA regulations in place and in approving the rezone. We talked a little bit at the beginning in the context of responding to the question about the reclamation, the plan. I just want to reiterate, we did addressed in our briefing at pages 31 to 32 some of the specific discussion regarding reclamation plans. Reclamation plans can be changed, special use permits and conditions could be changed. And so while it's true that the property could be reclaimed in a way that supports ecological restoration, that wasn't mandatory. And so it was appropriate for the board to consider that that was not mandatory. Similarly, the fact that it was subject to a reclamation plan, nothing precludes the county from having made a legislative determination to rezone it for the post-reclamation use. I mean, this mine has been in existence since the mid-1980s. It went through several expansions. The record shows that it's 85% of the site has already been disturbed. And so this is not a pristine and naked site in its current form, and it's appropriate for the board to have considered that. Just
to clarify though, is it accurate that the reclamation, if it's a zone of R120, would be different than a RRI? So it'd be different. The reclamation would, I mean, it's accurate to say it would look different.
It is accurate to say that it would look different because just in part, think about, if I'm permitted to have, I have less or I have a specific amount of open space I have to provide in RRI, right? So my reclamation plan would account for the fact that I have to have at least 40% of it in the open space designation. My reclamation plan might also look different if I don't, as the applicant has represented multiple times, but understand is not bound to. If you don't mine into the water table, then my reclamation plan also does not include the pit lake and the fencing around the pit lake. So there's many, many things that could change over time. If the mining just was stopped today, the reclamation plan would look different, notwithstanding the R1 to 20 zoning. And I think it's important, given the petitioner's reliance on the earlier 2005 R1 to 20 zoning of the Black River corridor, to you know, that did happen, and we understand that that happened. But with the withdrawal of the 24 acres immediately adjacent to the Black River and the protections of those shorelines, that becomes a different equation. So the Black River is certainly there. We don't dispute it's next to the refuge, but with the withdrawal of the 24 acres, those parcels have been removed, which have the most direct and immediate effect. And I am seeing myself at 27-ish minutes or so right now with my handy dandy timer, and I don't want there to be inadequate time for Mr. Burns to answer the board's very important questions to the county. But there was one last point I wanted to make before ceding the rest of the time to Mr. Burns. And that has to do with this idea about the adequacy of rural resource industrial lands. So there's a discussion in the briefing about the buildable lands report, which addressed urban commercial industrial capacity, and the county's separate industrial land study, which looked at rural industrial land supply. And that showed that there was significant constraints, including on parcels of 20 acres or larger, that were necessary to meet the county's 2045 employment forecasts. And so there was ample evidence in the record to show that the county had a shortage in taking this action. And looking at urban industrial capacity does not change that. Similarly, it's important to note that this is a rural industrial classification. We're not talking about rezoning this to an urban designation. We aren't bringing urban utilities. It has a rural focused, and with the board's concurrent action to limit the scope of uses, it is quite clearly intended to serve a purpose to support rural resource uses that are an important and considerable economic driver in Thurston County, which the board properly considered in weighing all of the factors leading to this decision. So I'm going to yield the rest of the respondents' time here to Mr. Burns to answer questions, or I'd be also happy to answer any other questions the board may have.
I just have one quick question. The petitioner mentioned that the county was under the impression that wet mining would not be allowed under the rezone. Is that the case, or can you speak to that issue?
I don't believe that's an accurate statement. There was discussion at the Board of County Commissioners, the two meetings that I referenced, the one in October, I believe, and the one in November, discussion about wanting to avoid wet mining because the applicant, the Black Lake Quarry, had represented that the rezone would allow them to basically pivot away earlier from the mining use as intended. But I don't think it was ever stated or represented that the rezone would prevent the wet mining. It's been our position all along that the mine exists, the mine has a permit, and unless and until all the conditions of that permit are met, rescinded, or modified, that is a vested land use.
Thank you.
I have a question related to that. So there was some discussion of walking away from the special use permit. Can you comment on that allegation?
I think it would be very difficult. Well, a couple of things. There's evidence in the record of the size of the reclamation bond that the applicant has posted. So walking away from the county's special use permit would presumably also trigger all of the adverse sequence of things that happen with DNR when that occurs. But I don't think walking away is the proper characterization. I do think that the mine operator could come to the county and agree to terminate the mine prior to it being fully mined out, revise the permit, and go through an appropriate reclamation plan. But I don't think that the mine operator could simply abandon the mine in its current condition, do no reclamation whatsoever, abandon all of the conditions related to ongoing monitoring. I mean, I happened to permit the expansion back in the day for the prior owner, and I can tell you there's a significant number of conditions associated with this mine. And so being out of compliance with those conditions carries significant consequences under county code. And so I would not characterize terminating the mining and pivoting to another land use as walking away.
Okay. And then what about the added layer of reclamation, for lack of a better way to describe it, that appeared in the hearing examiner's decision? And is that part of that analysis as well, or because of the rezone, would that part be modified, or would your clients be advocating to modify it?
I anticipate that anything that became a condition of approval, right, which I believe the condition speaks to conformance with the DNR reclamation plan, those conditions still have to be met. There's discussion, and don't have that record open right in front of me, but there's discussion of findings in the hearing examiner's decision, other factual information from that record. To the extent those aren't carried forward to conditions of approval, those are facts and information, but they're not binding future conditions on the owner.
Okay, yeah, I think there was a discussion of 300 trees, a lake, etc.
Right. Because there was
Yeah.
discussion of the reclamation plan. Because if I recall correctly, if you look at the mining criteria in place at the time, the applicant had to show that there was a reclamation plan for the post-mining land use, and there's a duty to comply with it, with the requirement of a reclamation plan. But the reclamation plan is ultimately controlled by the Department of Natural Resources through its.
Right. Okay.
And there's
Thank you.
there's a consistency requirement in those DNR regulations for the county to be able to weigh in. So the county would still have to say that the reclamation was consistent with local land use.
Okay, thank you.
Thank you. Appreciate the board's questions. I yield the rest of my time to Mr. Burns.
Hey,
Go ahead.
for the record, Travis Burns with representing Thurston County, and appreciate the yielding of time. Although I'll promise this will be short and sweet. I think board member Seidels asked for the county's perspective in regard to the alleged error that occurred during the adoption of the ordinance in the rezone, and the county concurs with the characterization. This was in fact an error. The intention of the board, from the county's perspective, was to rezone the property based on an approximation of the lower amount. I don't have the figures right in front of me, and for the map that was submitted by the applicant previously, and that is in the record today. As a matter of process, the county does plan to make an administrative action to make this clarification in the official record, and Ms. Burgess is correct. The current zoning geodata process that the county relies and enforces most of the zoning on has already been updated to reflect the intention of the board. We're just looking for, one additional administrative action to clarify the findings that were made with the original enactment. And happy to try to answer questions or ask staff to answer questions if there's anything further on that.
Not from me, thank you.
Drag set, anything? Hearing nothing, and I have nothing, so
Yeah,
thank
I
you.
was just processing that process. So
Okay. We'll keep on processing this process and move on. And go back to Ms. Newman for a reply.
Thank you very much. That is not a Scrivener's error. I'm not even sure the county can legally do an administrative action to change that. They have to literally amend they have to issue a new ordinance that amends what they did. They can't just go in and change what the law says. But I mean, that's not just fixing a typographical error. That is literally changing the law that they passed. And you have to adopt a new law to amend a law that you passed. I haven't even looked at the administrative, but I'm wondering what would have happened if we hadn't filed this appeal. Would they be making this change? But the more important point here is whether or not it's 270 acres or 240 acres does not affect our argument at all. Withdrawal of the 24 acres is not a different equation. Developing 240-ish acres with industrial uses on this site is a major, major issue. Property lines do not protect against impacts. Environmental constraints are not only within property lines. This is surrounded by environmental constraints. The groundwater and surface water from this property feeds directly into the Black River watershed. That is a water quality impaired river with endangered and threatened salmon. It's subject to a TMDL. Wetlands surround the property. There's Oregon spotted frog critical habitat adjacent to the property that would be impacted by this. There is a national wildlife refuge adjacent to the property. There are high groundwater hazard areas throughout the property. And I agree that the fact that we have these category 1 and 2 on the property prohibits certain industrial uses is evidence that this should not be rezoned for industrial use. This property cannot support industrial use. This is a major environmental constraint for this land.
Can
And
I drill down a little bit, Ms. Newman, on the cannot support industrial use question? Because as you know from my question to Ms. Burgess, I think that's important under the locational criteria. So I had asked Ms. Burgess, I said, oh, because of the CARA 1 critical area, there seem to be a bunch of industrial uses that can no longer occur, and therefore perhaps this parcel is more than minimally encumbered by environmental constraints, right? She had a pretty good answer, which was, well, that may have been true under the old RR1 zoning regulations, but as you yourself pointed out in your opening arguments, the RR1 allowed uses were changed, and it's so recent you can't even find them online. You have to go to the record to read what they are. In your brief, you say the actual Thurston 2045 code amendments authorized a much broader range of industrial uses under the RR1 zone, including aquaculture, meat processing, pesticide distribution, fertilizer manufacturing, concrete manufacturing, asphalt manufacturing, warehousing, and with an SUP, landfills.
I'm showing you that language.
Okay, let's see. Oh, yeah, lo and behold.
10409, permitted uses. They've added asphalt products, manufacturing of asphalt on the site.
And underline means that asphalt was added by the ordinance,
Yeah,
right?
this is the
okay.
amended version.
Yeah.
They've introduced this new aquaculture use, fish processing, hatcheries.
Okay.
I want to point out that, Black Lake Quarry could sell this land tomorrow. We have to look at what the law says. There was a lot of discussion about, well, what we'll do or we won't do or we will do. That is completely irrelevant. Someone could do aquaculture, fish processing, and hatcheries.
Right.
So then we have assembly, and there's just
let me ask you the follow-up here. All right, so this is the list of allowed uses under RR1. Now, the CARA 1 designation that applies to more than half of this property might prohibit some of those uses. And that really gets to the core of your argument that, hey, we're under more than minimal environmental constraints. So of those uses that we just saw, all those industrial uses, how many of them are now lost to the applicant because of the CARA 1 restrictions? I know asphalt's on that list.
There's a table 24.10-1, and it's Rec 638 at 2460. That table identifies restricted and prohibited uses within CARAs.
And that's up to date with the ordinance.
Involving asphalt, cement, concrete, chemical processing, hazardous materials, and waste.
Okay. So asphalt seems to be right out.
With limiting what a lot of the processing, there's processing allowed. There's a lot of uses on this list that the environmental constraints on the property wouldn't allow to be used.
Okay.
And maybe even they would allow. I mean, to be honest, the fact that I guess I don't think it's. I think that the bigger picture here is that the environmental constraints are critical to a thought of what the impacts of these uses are, even the ones that are allowed. The fact that there are industrial uses allowed at all on this site, they shouldn't be allowing industrial uses on this site because of the environmental constraints. That's another way to look at it.
And then my other question for you, maybe I should let you finish first, but I just wanted to plant it there in case you needed to check for it. It's adjacent to the National Wildlife Refuge. Has the U.S. Fish and Wildlife Service weighed in through public comment or any other forum as to their opinion about this rezone or any of the other developments there?
I can't. I I know my clients would know the answer to that question. I wish I could
I wish I'd brought it up
grab
earlier so we had
them.
time to poll them, but it was kind of in
I'm
my mind.
sure this was a major point of contention in the comments. I don't know the answer to that,
Okay,
but
all right, thanks.
and I do want to mention, I don't know if I said this already but environment, did I say property lines don't protect against impacts? Like environment constraints are not within property lines. So I want to point out, one of the board members said, I would not be considering this rezone if there wasn't a mine on the property. And that is such a critical point because the mine is temporary. And there is not going to be a mine on the property in 10 years. And they're saying they wouldn't consider it because of this area. One last point is that plan, the forest, the reclamation plan. So, we were talking earlier during my presentation about how reclamation works and, the wax. And I think there's a clear agreement that it's consistent with the underlying zoning. That's how the reclamation plan works. So now that the zoning changed, reclamation plan can change. And as was said, there's no vesting of a use with the reclamation plan. So they can ask for that to be amended. But I do want to make it clear that the forest, that plan that we've referred to many, many times in our brief, was literally officially the plan that was approved by DNR, required by DNR, with the assumption that the zoning was R120. And so if the zoning stayed the same as R120, that's the plan that was approved for reclamation under that zone. The thing that's going to change is with the new zoning, we'll have a different reclamation plan that ties to an assumption that this land will be used for industrial use. It will be a different, obviously they can't plant a forest there if they're going to use it for industrial uses. So they're of course they're going to walk away. They would not have asked for this rezone if they were planning to do anything comparable to, like what they promised to do with building this up to be like an ecological habitat with lakes and forest. I think that's everything. I would love to answer any more questions you have if you have any more, but I have nothing more to add.
Any other questions?
Not from me, thank you so much.
Yeah.
I don't have anything either. I'm sure I'll think of something 20 minutes from now that I wished I had said.
Of course, I thought of
Same here.
5 minutes into their argument that I wish I had asked Mr. Trahimovich, but
All right. Well, I appreciate all of the work that everybody has put into these arguments, and I compliment the lawyers on both sides of the fence with all their hard work on this case. And we will be giving it serious consideration and be issuing a decision by mid-August.
Thank you very much.
Thank you.
Yes, you're welcome. Thank you. We'll be off the record.